tenants, if they were past due on their rent, they were required to pay a certain percentage of their monthly rent to the landlord by January 31st.
Right.
Now that we're past January 31st, how did that play out? Are there any changes to that? Were tenants required to pay that 25%? And what can you do to educate us on that?
And the law required the tenants to pay 25%, but they didn't have to actually pay it until January 31st. And
Correct.
guess what? The law got extended to June 30th. So now the 25% doesn't even have to be paid until June 30th. And that's been going on since. So we're talking September 1st is when this started. September 1st to June 30th, which by my count is 10 months. The tenant can pay you zero as long as they pay the 25% on June 30th.
Hi, everybody. This is Jose Luis Morales. Welcome back to the Morales Group Show. This is episode number 53. Today, we've got a repeat guest. His name is attorney Brian Nomi. He's a local attorney here in Ventura County, specializes in bankruptcy and tenant law. He did a video recently that educated us on how to evict a tenant in California right now. And there have been some changes to the tenant law, and we kind of wanted to elaborate on some of those changes and further provide education to our landlord owners. Welcome to the show, Brian. How are you?
I'm doing wonderful. Thanks for having me on again.
Of course, of course. So the first interview that we did, Brian, was before January 31st. And I know that tenants, if they were past due on their rent, they were required to pay a certain percentage of their monthly rent to the landlord by January 31st.
Right.
Now that we're past January 31st, how did that play out? Are there any changes to that? Were tenants required to pay that 25%? And what can you do to educate us on that?
And the law required the tenants to pay 25%, but they didn't have to actually pay it until January 31st. And
Correct.
guess what? The law got extended to June 30th. So now the 25% doesn't even have to be paid until June 30th. And that's been going on since. So we're talking September 1st is when this started. September 1st to June 30th, which by my count is 10 months. The tenant can pay you zero as long as they pay the 25% on June 30th.
Wow. And then at that point, essentially, it almost feels like it's continued to get extended a couple times now. Like I imagine that landlords were feeling like, okay, I'm going to be able to collect at least 25%. If I don't collect the 5% by January 31st, I can move forward with an eviction. Now it's postponed another 4-5 months, essentially.
Right. Exactly. Until the end of, so basically it was going to end on January 31st, February, March, April, May, June, 5 more months. 5 more months. But there is some good news for landlords, which is the new law encourages landlords to apply for rental assistance. And the deal is this: if the landlord agrees to waive 20% of the rent, and then some governmental agency provides 80% of the rent, then at least the landlord's collecting 80% of the rent, but the landlord's forever giving up the right to collect the other 20%, which to me is a pretty good deal. If I was a landlord and I was getting zero, I would take 80% over 25% or 0%.
Absolutely. That sounds like a great opportunity for them. Now, at what point would they be able to collect this 80%? Is that something that they have to wait until June 31st to collect that, or can they do that now?
You would apply for that right now. Now, the landlord is not required to accept the 80%. The landlord could say, hey, I want to collect everything, and just not even participate in that program. That would be a stupid move for any landlord, I think. But you can apply for the 80% right now. And people have been asking me, how do you apply for it? My best advice is go to Google. You'll get referred to like the Ventura County Housing Development Agency or something like that. I don't know who to call. I don't know what the phone number is or the email address is, but I do know that there is a statewide program that's focused primarily on helping lower income tenants. So I think the tenants who are paying, $1,500 or $2,000 a month in rent are going to get their 80% rental assistance paid to the landlord a lot before the $5,000 or $10,000 a month tenants get paid any rental assistance. So that's how the state is prioritizing that. They're trying to help out the poorest residents first with this 80% rental program. So that's the good news. Along with the bad news is if you don't qualify for that, then you're stuck until the end of June 30th. But any landlord who's smart would want to cooperate with the tenant and try to get, fill out whatever application you have to fill out and hopefully make a deal. I mean, it benefits both the landlord and the tenant. So hopefully the landlord and the tenant would both cooperate to get that 80% paid to the landlord.
Well, I think it's about being aware of it because, to be honest, Brian, prior to this conversation, I had no idea that a landlord basically be compensated. So, as a landlord myself, I mean, it's just another option that I have available, as well as for all my landlord clients that we have available to be able to potentially collect. If you ask me, 80% is better than potentially 25% of the rent and possibly no money, and then having to move forward with an eviction at that time. So I think that's a wonderful program. And for our viewers, we'll do a little bit of research for you guys, and we'll provide a link down below so that you guys can be educated. What other changes, Brian, have happened since our last interview? I know that was one of the ones that most people were concerned about, the fact that if it got extended. Is there anything else that could help our landlord clients navigate through the waters of this?
The law is almost exactly the same. The law that started on September 1st basically was just extended in exactly the same form till June 30th. So that's what you need to know, is that there haven't been any changes. We're still under the COVID protections. The overall framework of California law has not really changed since the September 1st. I mean, from March of 2020 until September 1st, 2020, there were no evictions unless you could prove a serious threat to public health, such as people running a drug lab at your house, which basically I didn't see a single eviction during that 6-month time frame. So at least now we do have some tools available, and those tools have not changed. I'll just take 60 seconds and run through what those tools are so that your viewers know in case they missed my last interview, which, I'll make it fast, I'll make it brief. A landlord can evict a tenant for illegal conduct, for like selling drugs, or for destroying the property, or for subleasing, or for not giving keys, not allowing access to the premises. That's still legal to terminate on a 3-day notice. That's called an at-fault eviction. And the landlord still has the same no-fault grounds, which would require either a 30 or 60-day notice, which is the landlord is in escrow to sell the property, or plans to sell the property, or the landlord plans to have a family member move in, or the landlord has to do substantial remodeling that requires a permit just to keep the premises habitable. Those are all reasons to give a 60-day notice of termination to kick out those tenants. And so what I'm telling a lot of landlords is, if you have a choice between having a tenant in your property who's paying you zero or selling the property, you may as well sell the property. So and most of my landlords agree with that. So that's a lot of my business right there, is just getting rid of the problem tenant or the non-paying tenant, so that the landlord does not have to be forced to be a landlord and can sell the property. And there's another special exemption, which is if you're in escrow to sell to someone who's going to live in the property, you only have to give a 30-day notice. That's a difficult one. I've only done that once or twice, but that is available out there. So that's my quick summary of what the law is right now for landlords. Those are options that landlords have, and I'll tell you, I'm doing a ton of evictions, and I'm winning all my eviction cases for the landlord right now. So the landlords do have options. You don't have to just sit there and leave your tenant in your house not paying you any rent or otherwise causing trouble for you and other neighbors. There are tools that the landlord has.
I think that's one of the misconceptions, Brian. I talk to homeowners every day, and they're thinking because they read that there's a moratorium until June 31st that they basically have no options. And the purpose I want to do these videos is to basically educate them and let them know that they do have options. Obviously, you have to understand what your options are and then figure out which strategy is best. But just a summary, it's almost impossible to evict somebody because of non-payment of rent. But you can evict somebody because of breaches on the lease agreement, essentially.
Right.
As long as you're on a month-to-month. Now, this is one of the things that I learned recently, because obviously we went through it. One of our clients had a lease agreement that didn't expire until March. And essentially, we were under the assumption we had the property in escrow. that all we had to do was get the property in escrow and provide a 30-day notice, and then essentially we can just move forward with it. But essentially that complicated things a little bit. Can you elaborate a little bit on that, Brian?
Yeah, I think the situation you're talking about it was a like term lease, like a 1 year term that was in effect. Like the tenant may have been there for more than 1 year, maybe and it was just getting extended year by year. In other words, the landlord had a written agreement where the tenant could stay from one date in 1 year till the next date, 365 days later. Just kept on rolling that over, and the landlord is bound by that. The landlord cannot terminate that unless the tenant consents. So that was the problem that I think we encountered in that situation. So is that your recollection as well, or did I mistake?
Yeah, no, it's exactly right. We were going to use the notice of termination of tenancy, which is a CAR form. And basically we were going to say, hey, look, the property is already in escrow. Essentially, here's a 30-day notice because the property is already in escrow. But what we both didn't realize was the fact that they were on a lease. So essentially the moral of the story is if you're in the business of renting property, it might be in your best interest to have a month-to-month agreement versus a lease agreement, because a lease agreement, like let's say I have another client who has a lease agreement until August, essentially her options get limited because of the lease agreement, as opposed to if you have a month-to-month agreement. Obviously, the tenant that wants to stay there long-term, but the type of agreement that potentially you should be signing is a month-to-month. And I had this advice given to me by an eviction attorney years ago. When I asked him, I said, should I put it on a lease or a month-to-month? And he said, month-to-month gives you more options.
Yeah, exactly. Every landlord is residential. I mean, primarily I'm talking residential right now. Mm-hmm. You should just start off month-to-month if you can. I mean, some tenants want to have the security of at least having a 1 year term to start. A lot of times I do start my leases with a 1 year term, but always month-to-month. If you can do it month-to-month, that's the way to go. Because the tenant has that option too. All the tenant has to do is say, "Hey, I'm out of here," leave, and then the landlord would have an obligation to find a replacement tenant and mitigate his damages. So there's really no downside for the tenant. The term only benefits the tenant. The term does not benefit the landlord.
Yeah. Well, I think some landlords find a little bit of security. They're like, "Oh, I'm thinking that maybe the tenant's not going to move out, and I don't have to worry about rent for a year." At the same time, right now, with everything going on, it's my experience that it kind of limits the options that you have. So one of our viewers just asked us that she thought, and she's a local realtor, that she thought it was a 60-day notice for anybody that was in there for a year. My response to that is, it also depends now. It depends if they're current, if they're not current. It depends if they have a lease, if they're on a month-to-month. It depends if the property is in escrow or not in escrow. And I would say that all of those things play a factor now.
Yeah. I was in court about 7 or 8 days ago, and I just won a case where the tenant has been living at the property for like 7 or 8 years. Let me back up a little bit. The viewer's question is very good, which is California law changed like 15 years ago to say if a tenant has lived at normally it was just 30-day notice by either side, the landlord or the tenant. 30 days, either side could terminate. And then 15 years ago, they said, hey, longer term tenants who've been there for more than 1 year are entitled by law to a 60-day notice. Mm-hmm. And honestly, I think that's pretty fair. I think that if a tenant's been a good tenant for over a year, they should get 60 days notice, because it does take time for the tenant to find a new place to move to. But there is a special exception under the law which allows the landlord to give a 30-day notice, not a 60-day notice, even for a tenant who's been there for multiple years, if you're in escrow to sell the property to someone who's going to buy the premises. So that's a special exception to the 60-day notice. So, but that's an excellent question that was asked. And again, I just want to remind you, if there's something illegal going on, a serious breach of the lease, subleasing, criminal conduct or other things, all we have to give is a 3-day notice. So 3-day notice is there for serious breaches like that.
Is that even if they have a lease, or are we kind of handicapped?
The tenant is on a 10-year lease, and all of a sudden the tenant starts selling drugs out of the property. 3-day notice. That's all they get, and we can kick them out. Absolutely.
Perfect. Okay, so I think that this is more of a short episode, Brian. I just wanted to update everybody, give them a little bit more information as some of the dynamics that are going on. If you want the full interview, like Brian said, most of the California law is the same from the last interview that we did. You can find it on YouTube, How to Evict a Tenant in California. It's one of the top 3 videos on there. And Brian, if people wanted more information on this, or they're going through this situation, unfortunately, how can people get a hold of you?
The best way to reach me is my website, www.briannomi.com. Hopefully we can put that link to my website in my show notes. I'll give my phone number right here on the video, which is 805-444-5960, and you'll find out that I answer my own phone. And I usually answer my own phone on the first ring 90% of the time. That's how I hustle and get business, which I'm sure you can relate to.
Oh, yeah.
But I take phone calls all the time, and I never charge for phone calls. So people are more than welcome to email me or reach out with a phone call or a text. I'm very responsive, and I'm happy to answer questions, and I never charge for phone calls.
Awesome, guys. Thank you so much, everybody. This was the Morales Group Show. This is episode number 53. Attorney Brian Nomi. We're going to stay up to date on this topic. So if there's any changes that happen from here to June, we'll do an updated video. Thank you so much, everybody. And we appreciate your time.
All right. Nice to talk to you guys.